Hello students, I hope you all are doing well. Welcome to the next session of the company law. In the last session, we had started with the topic general meetings. We have not yet completed that topic. So in the part 1, we have talked about the pre-meeting procedures. Today we are going to talk about what will happen during the meeting and the post-meeting. So let's get started. So here, I have given you the prerequisites of the general meeting during our last session. So before meeting, the notice has to be served under section 101. Explanatory statement is required to be given when there is a special business under section 102. Now we will proceed further and take it further during the meeting and the post meeting. So during the meeting, first we will start with the quorum, chairman, proxies, votings and the resolutions. Okay, so let's try to understand during the meeting. So during the meeting, the first provision is about quorum for the meeting. The first provision is about quorum for the meeting. So let me just put quorum for meetings. Section 103. So it says that unless the articles of the company provide for the larger quorum, the quorum for the meeting will be as follows. So we need to understand the quorum for the public limited company and the private limited company. So quorum may differ for public and private. Okay. So let's try to understand first about public company. Let's first talk about public company, what will be the quorum, and here we will talk about private company. So when we say public company, so if any articles of the association provide for the larger quorum, then it will be followed, but if in normal cases the quorum will be as under for the public company and private company. So for public company, the first criteria is if number of members is more than 1000, then the quorum shall be 5 persons. If number of members more than 1000, then quorum is 5 members personally present. If number of members more than 1000 but less than 5000, so in that case what will be my quorum? 15. And if number of members exceed 5000, just a moment, I think here I need to put the word up to, then my quorum would be 30. Okay. So 5 persons present and voting, 15 persons present, members present and voting, and 30 members present and voting, that will be considered as quorum for the meeting. And for private is very straight, it's only 2. Okay, members present okay. So this is the quorum requirement. So members personally present refers to the members entitled to vote. So not only present, but they should be entitled to vote, okay, as per the articles of association and the shareholding they are holding in the company. So if the quorum is not present, whether company will be considered as valid, whether meeting will be considered as valid. So company will have to, if the quorum is not present, within half an hour from the time appointed for the holding the meeting. If the quorum is not present, then the meeting shall stand adjourned to the same day in the next week at the same time and the place. So as the board may determine, okay, or it may so happen that board may determine the different, okay, or date or time or place. So as per that. And if the meeting is called by a requisitionist and the extraordinary meeting, and it is not present, the quorum is not present, that time the meeting will stand cancelled. Okay, so this is the requirement of the quorum. The quorum has to remain present in the meeting. If the quorum is not present during the business transacted for some matters, then those matters will not be taken into consideration. So quorum is one of the very important criteria, okay, to consider the meeting as valid or not. Then chairman of the meeting. Let's talk about chairman of the meeting. The provision for the chairman of the meeting is given under 104 of the Companies Act 2013. Now, who is the chairman? So, it says that unless otherwise provided in the articles, the members personally present, okay, shall elect among themselves to be the chairman by show of hands. So, who will elect? The persons, the members, you can say, personally present in the meeting shall elect among themselves to be chairman by show of hands. So by show of hands, okay, is one of the criteria to choose the chairman. But if the poll is demanded on the election of the chairman, then the chairman elected by the show of hand, okay, will remain or continue to be the chairman until some other person is elected as the chairman, okay, by poll. So what are the powers of the chairman? So very basic thing that comes to anybody's mind when hearing the word chairman, that he must be having so many powers, or whether he just the chairman. First of all, he is not a chairman of the company. Try to understand. He is just a chairman of the meeting. Okay, so 104 talks about the chairman of the meeting. So one basically who manages the meeting and ensures that all the compliances are required, decorum, you can say, is maintained at all times during the meeting. He may execute the minutes of the meeting. So he has prima facie all the authority to decide all questions which will arise during the meeting, and which will require the decision at the time. So he may have the casting vote also. So he must observe strict impartiality, even though he must be personally strongly opposed to anything, okay, for that matter. So the casting vote can be given, okay, to the chairman. That is one of the right. So chairman will have right to cast, you can say, casting vote. So what is meant by casting vote? So if it is duly empowered by the articles of the association of the company, the additional vote can be given in case of equality of the votes on a particular business. So chairman will have the right for the another vote. So these are the provisions relating to the chairman one needs to understand. Then we will talk about the proxy. So proxies provision are given under section 105 of the Companies Act 2013. What is meant by proxy? So proxy is a kind of representative who is entitled to attend the meeting but not entitled to discuss upon the matters, and he is only entitled to vote when the poll is demanded. So proxy is a kind of provision where a member is unable to attend the meeting but he wants to represent something during the meeting. So let's try to talk about the proxy. So 105 deals with the provisions of the proxy, which states that subsection 1 states that any member of the company who is entitled to attend and votes at the meeting of the company shall be entitled to appoint another person as the proxy. So I just need to write down this. Any member of the company who is entitled to attend and vote at a meeting shall be entitled to appoint another person as proxy. Okay, another person as proxy. So why? To attend and to vote at the meeting. But a proxy shall not have a right to speak. A proxy can only vote. Proxy can only vote when poll is demanded. Okay, a proxy can only vote when the poll is demanded. So proxy is not entitled to vote, okay, when there is a voting happening with the show of hands. Now the proxy, okay, a person can remain a proxy for maximum 50 members. A proxy can represent maximum 50 members. Maximum 50 members to entitled to vote. A proxy received 48 hours before the meeting will be valid. So these are some of the important pointers for the proxy. So what needs to be remembered over here? So an option can be given to the member that he can allow the proxy to attend and vote in the meeting. But the 48 hours before the meeting, a proxy has to be informed. The member has to inform to the company that okay, he is going to appoint this person as a proxy. So any member of the company who is entitled to attend and vote of the company can appoint another person as a proxy. But proxy will not have right to speak during the meeting. He will not have right to speak during the meeting. Okay, and he can only vote when the poll is demanded. So he cannot vote when the matter is taken up by the show of hands. So he is not allowed to vote. Why? Because your one vote will be equivalent to one share is voting share is equivalent to one vote. For that matter, the proxy can be entitled, but he can remain a proxy for 50 members also, because he is only entitled to vote during the poll when it is demanded, and there won't be any harm for the company also. That is the reason this provision is given. Only 48 hours before the meeting will be considered as valid. Okay, so far we have completed 3 important provisions: quorum, then we have talk about chairman of the meeting and the proxy. Now we'll proceed further and we'll try to understand what will happen during the meeting and how the voting will take place. So now let's talk about voting. So voting sections are given from sections 106 to 109. We'll talk about them in detail. One not 9. I should write down 110. Okay. So why the voting is important according to you? Can you guess it? So whether when the meeting takes place with an agenda, so agenda in the items are given in, during the meeting in the notice, and the decisions to be taken up by the company's members, which are crucial for the working of the company. So when the meeting takes place, to discuss and decide upon the topics which are important or the agenda items which are important, okay, during the meeting, and these particular decisions will require the consensus from the members who are attending the meeting, and this consensus is reacted through voting. Okay, so you can say that the decision in the meeting requires consensus of the members attending meeting and this consensus is reached through voting. So voting can take place in various ways. We are going to see that. But first we need to understand section 106, which talks about the restriction on the voting rights. And it provides that the articles of the association may provide that no member shall exercise any voting rights in respect of any share registered in his name and on which any amount is due from him on calls or any other sums payable to the company. So when a person is having some kind of you can say the call on money pending, okay, so he may not be entitled to vote. The subsection 2 says that, also suggests that a company shall not prohibit any member from exercising in voting rights any other ground except the grounds mentioned in subsection 1. Okay, so no other ground can be made applicable for the voting purposes. Only the ground which are given under 106 subsection 1 will be made applicable. That the call money is pending and any other dues, okay, which are supposed to be paid by the member is not paid. So in that case, he may not be entitled to vote. Okay. So now we are going to move on to the very important part, which is types of votings, or you can say ways of voting. Ways of voting, okay, during the meeting. So there can be different ways of meeting. One needs to understand. Okay, so one by one we'll try to understand. So let's talk about it. So, voting by show of hands. Voting by show of hands, which is given under section 107. Voting by electronic means. 108. Voting by demand of poll. 109. And voting by postal ballot. 110. Okay, so these are 4 ways of voting, okay, which may happen, by which the decisions can be taken during the meeting. So let's try to understand one by one the ways of all these votings. So first we will talk about voting by show of hands under section 107. So unless the voting is demanded, as per section 107, we says that unless the voting is demanded by way of poll or by electronic means, the voting should be by way of show of hands in the first instance. So always remember, if there is no demand made by the members present during the meeting for the voting by electronic means or for voting by demand of poll, then voting should be conducted by show of hands. So the declaration by the chairman of the meeting in the minutes book shall be the conclusive evidence that the resolution is passed for that effect. So voting by show of hands, in case of the show of hands, the person present during the meeting, okay, will have one vote. Okay, now it may so happen, okay, there are 10 members present during the meeting, and 2 members are having the shareholding of 70% and the other 8 are having the shareholding of 30%. But in that case, if 8 members are giving the vote in favor of the resolution, then the resolution can be passed by show of hands. So that may be detrimental to the interest of the majority shareholders, and that is the reason the other provisions are given in the law, that is voting by demand of poll or voting by electronic means. So when there is a problem which will occur during the voting by show of hands, then the members can put the demand that, okay, we want to have the voting by demand of poll. But there is a procedure laid down for voting by demand of poll under section 109. We will talk little later. First, try to understand voting by electronic means. So this is a kind of new mode of voting in the meetings which has been introduced, okay, in this particular new law, that is Companies Act 2013. In the erstwhile Company Law 1956, no such provisions were there, okay, relating to the voting by electronic means. So this section provides that a member in the prescribed class of companies may exercise his right to vote by electronic means. What is voting by electronic means? So company should provide the exercise of right to vote by electronic means. So this particular class of companies, which class of companies should provide it? So every company which has listed its equity shares on a recognized stock exchange, and every company having not less than 1000 members. Okay, every company on the stock exchange and minimum 1000 members shall provide. So you can say there are two important. Every company, okay, listed, and every company having more than 1000 members. Okay, so these companies should have voting by electronic means. So at first instance, we can say at first instance. So a member may exercise his right to vote through electronic means on the resolution, and the company shall pass such resolution in accordance with the rules. So there are rules for that. So notice should provide it shall be sent to the members, directors by register pros through electronic means. The notice to be hosted on the website. Notice contain the particulars how the facility can be provided to the members to vote by voting by electronic means. So everything should be properly stated. All the facilities should be provided by the company to the voter, to the members of the company to vote during the general meeting. So notice shall indicate the process and manner of for voting by electronic means. Indicate the time schedule, including the time period during which votes may be cast by remote e-voting. Provide the details about login ID. Everything, okay, should be properly provided. So there has to be some cutoff date and time of commencement of the voting, date of time of end of the voting. Okay, cutoff date should be properly provided. Normally 3 days timeline. Okay, time for opening of e-voting. The facility of remote e-voting shall remain open for not less than 3 days. So minimum for 3 days that facility should be given, and shall close at 5 p.m. on the date, okay, preceding the date of general meeting. So before the general meeting, okay, the voting, e-voting should be completed. So this facility should be given so that the person who is staying very far away, okay, from the company, and he should have the right to vote. He may not be may not come for the meeting, but he should have the right to vote during the meeting. So there are some provisions relating to the scrutinizers also. So scrutinizer can be appointed, and then he will scrutinize, he will count the vote for that matter, and then the voting can be completed, okay, for that purpose. So we'll not go in so much of details, okay, just to understand that. So this is one of the newest way of voting by demand of poll. So for again, who can demand the poll? That is the first question. Then what should be the time for taking the poll? Then appointment of the scrutinizer and manner of taking poll and result. So in the case of the section 109, okay, which provides that before or on declaration of the result of the voting on any resolution by show of hands, the chairman of the meeting on his own or on demand made by the specified members order for the poll. So who can demand the poll? First of all, he may be either chairman or the specified members. Specified members. So who are those specified members? Who are having not less than. So you can say that more than 10% voting rights. Okay. These members can demand the poll. So the example which I had given to you during the voting by show of hands, where 30% of the voters, 30% of the voters were minority shareholders, but they were large in numbers, and they were in favor of the decision. So if the voting is taken by show of hands, then the resolution will be passed. But when it will be demanded at poll, then resolution may not be passed. But because in case of the demand of poll, one share is equivalent to one vote. So in any other member present in the person or proxy were allowed having not less than 1/10. So basically the demand of poll can be done by chairman or specified members. After demand of poll is done, then the scrutinizer's role will come into place. So it can be the demand can be done before or after the declaration of the result. And then scrutinizer role will be there. So scrutinizer will be appointed, and the scrutinizer will scrutinize everything. He will have the ballot box, he will take all the details, then he will count the votes for that matter, and then he will prepare a report, give it to the chairman, and the chairman will declare the result. So in such a way the demand of poll meeting can be concluded. So scrutinizer will have to ensure proper conduct of the polling process. He should maintain proper records of the poll. He should submit the report to the chairman. So we shall contain the details of the votes cast in favor and against the resolution. And scrutinizer shall give a report to the chairman in form number MGT 13, which is provided in the prescribed form. So after that, chairman of the meeting shall ensure that scrutinizers are provided with register of members, specimen signatures of a member, attendance register, register of proxies, everything. Then only he can be in a position to give the report. Now we will talk about voting by postal ballot. So what is voting by postal ballot? Shareholders who are not unable to attend the meeting, there should be a requirement for that purpose, which will enable them to vote by postal ballot for some key decisions. So this is a kind of provision where central government may decide. Who can decide? Central government can decide which resolution should be passed by postal ballot. So this right is given to central government. It can specify the matters, which matters can be passed by postal ballot. The central government may by notification declare to be transacted only by means of postal ballot. So me in respect of any items of the business other than ordinary business normally, and any business in respect of which director or auditors have right to be heard, can transact by means of postal ballot. So postal ballot things are very similar to the you can say voting by electronic means. So postal ballot can also be done by register post or speed post, through electronic means like register email, or through courier service. So votes can be collected. So it should be in safe custody of the scrutinizers. No person shall destroy the ballot papers and declare the identity of the shareholder. It should be preserved properly. So scrutinizer will again prepare a report in which particular cases postal ballot is can be postal ballot voting can be conducted. So like in case of the alteration of the object clause in the MOA, then alteration of the articles of association, if company wants to change the place of register office outside local limits, change in the objects, issue of shares with differential rights, buyback of shares, election of director. So there are many matters which can be taken up by the postal ballot. So members who are not entitled to come or who cannot come and vote, for them this is the facility made available for such members. So these are the very important points. I hope you understood it very well. So you please first make a note of all the sections we have completed so far, from section number 103 to 110. proxy, the question can be asked for the short note as well. Okay. So far we have completed many provisions during the meeting: quorum, chairman, proxies, and now we'll move on to the resolutions. So under section 111 we says that the circulation of the resolution should be made to the members of the company when the notice is to be circulated. Section 112 and 113 are given for the 112 is given for president and governor. So when president and governor is the member of the company, then he may appoint anyone. Okay, so the a person who is appointed by president or the governor will have all the rights of president and governor as a member in that particular company to represent. In case of the company, body corporate, which is the member of the company, so section number 113 will be made applicable, where body corporate, if it is a member, then the representative of the body corporate may go and attend the meeting. Okay, that is given under section 113, and that representative should be duly authorized by the company to attend the meeting and to vote in the meeting. Now let's focus on the resolutions. Okay, now we'll talk about the resolutions. So resolutions provisions are given from section number 114 to 117. So in the layman's language, one can say that a resolution is a type of decision taken by the persons present and voting while doing transacting a business during the meeting. So the votes in favor, okay, can be more than the votes which are not in favor. So that is the general meaning of the resolution. So section number 114 says that there are two types of resolution. Okay, so as per section number 114, two types of resolutions can be there. First one is ordinary, and second one is special resolution. Don't get confused between ordinary business and the special business, which we have already done. Ordinary business are of four types which we had noted down. The special business which should be taken up during the AGM. Okay, special business is something different, okay, where the explanatory statement has to be provided. Now we are talking over here, okay, the ordinary resolution and special resolution. So what is mean by ordinary resolution? and special resolution. So ordinary resolution, it is passed by simple majority, that is more than 50%. So it is passed by simple majority. Always remember, okay, it is passed by simple majority. For example, or you can say that is more than 50%, okay, and this is passed by 3 times of the majority. It is passed by three times majority, that is more than 75%. Okay, so this is the major difference. Simple majority is more than 50% and super majority is more than 75%. Okay, so the sections section 714, it provides that resolutions shall be ordinary or special. Ordinary resolution, if votes cast in favor of the resolution exceeds the votes, okay, if any cast against the resolution by the members. So subsection 1 of section 114 states that a resolution shall be ordinary resolution if the notice required under this act has been duly given and it is required to be passed by votes cast, whether on show of hands or electronically or on poll, as the case may be, in favor of the resolution, including the casting vote of the chairman, if it is more than, okay, cast against the resolution by the members. So it is simple majority. What is special resolution? Subsection 2 talks about it. So you can just say that the ordinary is given under 114 subsection 2, which says that a resolution shall be special resolution when the intention to propose the resolution as special resolution has been duly specified in the notice calling the general meeting. The notice required under this section has been duly given, and basically votes cast in favor of the resolution normally are 3 times the votes cast against the resolution. So the special, who will decide that a resolution is ordinary or special? It is the act which specify, okay, that this matter should be taken up during the meeting and the resolution should be ordinary or special resolution. So when we talk about the special resolution, okay, it is by specified majority of the 75%. Resolution shall be set out in the notice properly that this is the type of the special resolution which is required, and notice must state that the resolution is to be passed by the special resolution. Then notice should be properly served, that is 21 days clear notice, and at the same time, as per section 102 of the Companies Act 2013, the explanatory statement should be provided to the shareholders. It should be annexed with the notice so that they can take the decisions properly. So the question will always arise how one will come to know that a section of the act requires passing of ordinary or the special resolution. So whenever the statement like this, that company in general meeting may by special or ordinary resolution do this thing, if such kind of wordings are there, you need to follow that. So normally when I'll give you the small example, alteration of the MOA may happen with small ordinary or special resolution. So all types of alteration except one, that is a capital clause, can only happen by ordinary resolution. Okay, but all other alterations can only be possible by passing the special resolution. So where you will require super majority of more than 75%. So super majority of 75% means 3/4 of the majority. I can just add over here 3/4 of the majority. Section 115 says that resolutions requiring special notice, the provisions are given under section 115. So they in some of the resolutions the special notice is also required. Where any provision of the Act specifically requires or articles of the company so require that special notice is required to be given. Okay, then the notice of the intention to move such resolution shall be given to the company by such number of members holding not less than 1% of the total voting power, as may be prescribed, has been paid up. So special notice is required to be given in some cases. Where specified in the Act. So for example, to appoint an auditor of a person other than retiring auditor, to stand for the directorship, to remove the director, okay, all these are special notice. Less than not less than 1/10 not less than So this is just one of the provision over here. Section 117 says that okay, the resolution, the agreement should be filed with the registrar within 30 days. So this is just a compliance part of it. So let's now proceed further with the meeting, the last part of it. You may just write it down, this particular part, and then we can proceed with the last part of the session. I will proceed with the last part of today's topic, minutes. 118. So section 118 says that every company shall cause minutes of the proceedings of every general meeting. So here we can say that every company shall prepare minutes shall maintain minutes of proceedings of. So the first point is every general meeting or any class of shareholders or creditors meeting or every resolution passed by postal ballot every meeting of board or its committees okay. So all these meetings should be properly maintained, prepared as per section 118. We should be kept within 30 days, okay, shall maintain within 30 days of the conclusion of every such meeting concerned. So within how many days? Within 30 days. Within 30 days. So there are procedures for it. At the same time, companies will have to adhere to the secretarial standards. Okay, so we'll talk about that. So for this, the rule number 25 of the company's management and administration rule 2014 will be made applicable. The minute book shall be consecutively numbered. So few important points we need to remember over here. Regarding minutes, the minute book shall be consecutively numbered. Minute book shall contain fair and correct summary of proceedings. All appointments made at any of the meetings shall be included. Matters to be included or excluded can be decided at the discretion of chairman, every company shall observe standards prescribed by ICSI. Okay, so these are some of the important points. The minute book shall be consecutively numbered. It should contain fair and correct summary. It should contain fair and correct summary of the proceeding. This is important. Okay, so it should always contain the summaries. All appointments should be properly included, and what is to be included or what is to be excluded, okay, can be only decided at the discretion of the chairman. At the discretion of the chairman. So every company shall observe the secretarial standards while preparing the minutes of the meeting. Now, in case of the board meeting, okay, when the dissenting directors should also be mentioned. Okay, so all the secretarial standards should be properly maintained. Distinct minute book should be maintained for each type of meeting. Like general meeting should have a different book, board meeting should have a different book, creditors meeting should have the different books. The minutes of the proceeding of each meeting shall be entered in the books maintained for that purpose within 30 days of the conclusion of the meeting. Every page of the minute book shall be initial or signed, and the last page of the record, okay, or should be dated and signed. Okay, in case of the minutes of the board, the chairman of the said meeting or the chairman of the next succeeding meeting. In case of the minutes of the general meeting, the chairman of that particular meeting or director authorized by the board. In the case of the death or inability. In case of every resolution passed by postal ballot, the chairman of the board within aforesaid 30 days, okay, he can just mention it. So where the minute book should be, okay, kept, minute book should be kept at registered office of the company, okay, along with the other statutory records. And minute books of the board and committee and the general meeting should be permanently preserved and should be in the custody of the company secretary of the company or any director, okay, to whom the authority has been given. So these are some of the provisions of the minutes one has to, okay, properly followed. So we have completed so far all the important points relating to the meetings, as we have seen over here. So inspection can also happen as per section 119. It may be kept at the register office of the company. So general meeting minutes can be inspected by the members. It is open for the inspection during business hours. So those rights are given without any charge. At least 2 hours can be allowed for the members for the inspection purpose. So if any copy wants to be given, okay, if he wants to get some copy of the minutes book of the general meeting, he can be provided with the copy as well. So all these provisions are given under section 119 of the Act. So under section 120, maintenance of an inspection of the documents, it seeks to provide that any document, record, register of minute required to be kept by the company or allowed to be inspected or copies given to any person may be kept or inspected or copies given as the case may be in electronic form. Now it is a new provision that one can maintain the records in the electronic form as well. So I hope you have understood all the provision very well of these prerequisites of the general meeting, before the meeting, during the meeting and the post meeting. So it's a very lengthy chapter. one needs to thoroughly read all the provisions before understanding and before attending or before conducting any such type of meetings. So with this, okay, we'll conclude with this today's session. So we have completed the topic relating to the general meetings and the minutes as well. So please do watch this video, read the notes carefully. Thank you so much for attending and listening to this particular video and attending this video. We will come up with a new topic in our next session. Thank you so much.